Hello everyone, I'm Harshitha. I'm the Legal and GK faculty at Abhyaas. So today we'll be doing the paper analysis for the legal reasoning part for the CLAT examination 2022. So average score, not average score, the good score for this section is 25 to 27. So for the overall paper, the good score is around 105 to 115. So in this legal reasoning section, we'll be doing the first passage. So I am discussing the paper based on the master key. Clear? Yes. So passage 7 is talking about writ of mandamus. Um, Passage 7 is talking about writ of mandamus. So writ is a public law remedy. It refers to a formal written order issued by judicial authority directing an individual or authority to do or refrain from doing an act. This is the definition of writ. So the High Court, while exercising its power of judicial review, it does not act as an appellate body. It is concerned with the illegality, irrationality and procedural impropriety of an order passed by the state or statutory authority. So as we all know, only High Court and the Supreme Court have the authority to, only these two courts will have the jurisdiction to, file petitions for writs, right? So here also writ of mandamus, only High Court is having the High Court or the Supreme Court has the jurisdiction to trial this matters. A writ of mandamus is issued by a court commanding a public authority to perform a public duty belonging to its office. It can be issued only when a legal duty is imposed on the authority and the petitioner has the right to compel the performance of such duty. And a writ of mandamus may be issued in favor of a person who establishes legal right in himself. It may be issued against a person who has a mandatory legal duty to perform but has failed or has neglected to do so. Okay, so usually it means that whenever a person is supposed to do his legal duty and if he fails to do so or neglects to do so, then the petitioner can file a writ of mandamus in the High Court. Clear? And the writ of mandamus is most extensive in regards to its remedial nature. The object of mandamus is to prevent disorder emanating from failure of justice and is required to be granted in all cases where law has established no specific remedy. Clear? So this is the overview of the passage. Now we'll be answering the questions. Let's see what the answers are. Yes. The government of a state made a rule to make it discretionary to grant dearness allowance to its employees. One of the employees filed a writ petition seeking a mandamus to compel the government to grant dearness allowance. In the given situation, which of the following statements is true? So here option A is saying that writ of mandamus cannot be granted as no legal duty was imposed on the government to grant dearness allowance. Writ of mandamus cannot be granted as a statutory right was conferred on the employee to receive dearness allowance. Writ of mandamus can be granted as it is public law remedy. Writ of mandamus can be granted as it is discretionary remedy. Okay, so here we can clearly say that after reading the passage, it is clear that writ of mandamus cannot be granted. Okay, so here the reasoning is different for these two options. What it is saying here, there is no legal duty that was imposed on the government to grant dearness allowance, and for this option it says that it cannot be granted because as a statutory right was conferred onto the employee to receive dearness allowance. Okay, so as discussed in the passage, so this option would be more relevant because there is no legal duty that was imposed on the government to grant dearness allowance because it is discretionary in nature. Clear? So hence option A would be the right answer. Next, A public spirited citizen filed a writ petition seeking a mandamus to compel the government to make a law to curb the ill effects of climate change. In the given situation, which of the following statements is true? Writ of mandamus can be granted as it is an equitable remedy. Writ of mandamus cannot be granted as no legal duty is imposed on the government to pass a law to curb the ill effects of climate change. Writ of mandamus can be granted as it is a discretionary remedy. Writ of mandamus cannot be granted as there is no violation of legal right. Clear? So here also it is definitely writ of mandamus cannot be granted. But for what reason? Here we are not talking about violation of fundamental rights. It's clearly there is no legal duty that is imposed on the government. Okay, so hence it would be option B. Okay, writ of mandamus cannot be granted as no legal duty is imposed on the government to pass a law to curb the ill effects of climate change. Next, Mr. A and Mr. B are parties to a contract of sale of goods. Upon breach of contractual obligations by Mr. A, Mr. B filed a writ petition seeking a mandamus to compel Mr. A to perform his obligations under the contract. In the given situation, which of the following statements is true? So, which of the following statements is true here? Here also writ of mandamus cannot be granted. It is option C. Writ of mandamus cannot be granted because Mr. B's right under the contract is a private right. Okay, it is since it is a private right and it is not a statutory duty or it is not a legal duty that is imposed. Clear? Since it is something between two people. Okay, that is the reason writ of mandamus cannot be granted. So if you go back to the passage, it means that writ of mandamus is issued by a court commanding a public authority. Clear? Commanding a public authority to perform public duty. So here it is not a public duty. It is between two individuals and it is about a contract of sale of goods. So that is the reason it is a private right. So it is option C, and writ of mandamus cannot be granted. Next is a licensing officer is under a statutory duty to issue a license to an applicant who fulfills the conditions prescribed for the issue of such license. Mr. X, an applicant, fulfilled all the conditions prescribed for the issue of such license, but his application for issuance of license was rejected by the licensing officer. In the given situation, which of the following statements is correct? So in this scenario, definitely writ of mandamus can be granted because the applicant has fulfilled all the conditions prescribed by the licensing officer. So hence it will be granted. But so option A and option C are saying that it can be granted, but for what is the reason? Writ of mandamus can be granted compelling the license officer to issue the license. Writ of mandamus can be granted as it is the discretion of the licensing officer to grant license. Definitely it is not the discretion of the licensing officer because he is under a statutory duty and he is bound to issue a license to the applicant whenever the required conditions are fulfilled. So it is option A, writ of mandamus can be granted compelling the license officer to issue the license. Okay. Next, which of the following statements is incorrect? Writ of mandamus may be issued in favor of a person who establishes the existence of a legal right. This is a true statement. Writ of mandamus may be issued against a person or authority who has a mandatory duty to perform but has failed or has neglected to do so. This is also a true statement. Writ of mandamus is purported to prevent disorder emanating from failure of justice. This is also true. Writ of mandamus may be requested to be issued to compel performance of private duties which may be administrative, ministerial or statutory in nature. This is incorrect because writ of mandamus basically requests the other person to fulfill, like complete the performance of the promise or whatever. Okay, they are bound to do it. Clear? So, but it is not of private duties. Okay, it has to be a legal duty. Clear? So, option D is the right answer. Clear? So, with this we have completed passage 1. I mean the first passage from the legal reasoning. Yes. So the next passage is based on constitution. So here, to maintain the secular character of the Indian polity, not only does the Constitution of India guarantee freedom of religion to individuals and groups, but it also against the general policy of the Constitution of India that any money be paid out of the public funds for promoting or maintaining any particular religion. Accordingly, it is provided in the Constitution of India that no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. This does not prohibit the state from enacting a law to incur expenses for the promotion or maintenance of any particular religion or religious denomination. But by such law, no person can be compelled to pay any tax, the proceeds of which are to be so utilized. This, however, does not invalidate levy of a fee to provide some service. Thus, a fee can be levied on pilgrims to a religious fair to meet the expenses of such measures taken to safeguard the health, safety and welfare of the pilgrims. Okay, generally the people are not people cannot be compelled to pay any kind of taxes. Okay, but it can be collected, the fee can be levied only on only when whenever there is any religious fair to meet the expenses, to meet the expenses and to take proper measures to safeguard the health and safety and welfare of the pilgrims. Okay, on these conditions the tax can be levied from the pilgrimers. Okay, from the people. Such fee levied by a state will be valid because the object of such contribution is not to foster or preserve religion but to control secular administration of religious institution. So this is about collecting of taxes from the people for religious purposes. So now we'll see the questions. Mr. A taxpayer of various taxes levied by the state government, filed a writ petition for issuance of writ of mandamus directing the state to forbear from spending any amount from the public funds of the state for renovation of water tanks belonging to a Hindu temple in the state. These tanks were used by the general public, irrespective of their religious affiliation, for bathing and drinking purposes. In the given situation, which of the following statements is correct? The state is promoting or maintaining Hindu religion? No. The state cannot be said to be promoting or maintaining the Hindu religion. The state is compelling citizens to pay taxes for promotion of Hindu religion. The state is compelling citizens to pay tax for maintenance of Hindu religion. These two statements are also incorrect. So hence it is option B. Clear? The state cannot be said to be promoting or maintaining the Hindu religion. Okay, here the public funds are used for renovation of water tanks and that belongs to a Hindu temple in the state. Okay, but in reality these tanks were actually used by the general public, so there is no scope of religion here. So it is option B. Next, communal riots between religion A and religion B resulted in the destruction of places of worship of both religions in a state. As a result, the state government utilized public funds for restoring the places of worship of both religions A and B. In the given situation, which of the following statements is correct? What will be the answer for this? Definitely the state government's act is not violative. Okay, it is not violative. So option B and option D are saying that it is not violative. As it is not promoting or maintaining any particular religion, as it is promoting or maintaining a particular religion. No, here since both the religions, a holy place is destroyed, so that is the reason it would be option B. Okay, the state government's act is not violative because it is not promoting or maintaining any particular religion. Clear? Next, communal rights between religion A and religion B resulted in the destruction of a place of worship of religion B in the state. As a result, the state government utilized the public funds for restoring the places of worship of religion B. In the given situation, which of the following statement is correct? It is here also the state government's act is not violative of the Constitution of India, as it is not promoting or maintaining a particular religion. Okay, since due to the communal riots there was a destruction of destruction of a place of worship that belongs to B. Okay, so in this scenario also the state government is not promoting any or maintaining any particular religion, and hence it is not violative to the Constitution. Next, a state government passed a law making it mandatory for all residents of the state to pay hefty pilgrimage tax so as to aid the state in organizing a popular religious pilgrimage in that state. The said pilgrimage is undertaken only by followers of religion X and draws a large number of followers of religion X from all over the country to the state every year. In the given situation, which of the following statements is correct? Definitely the state government's act is violative. So option C and option A are saying that it is violative. As it is not promoting or maintaining the religion X, this doesn't make sense because it is saying that the state government's act is violative as it is not promoting or maintaining religion X, but that is an incorrect statement, as it is compelling the citizens to pay tax for promoting or maintaining religion X. Okay, so it is option C. Here the state government's act is violative because it is forcing the citizens to pay taxes for promoting or maintaining religion X. Next, the last question of this passage. The object of a state legislation is to provide for the better administration and governance of certain Hindu religious endowments, where religious endowment means, so here they have defined what a religious endowment is: the property belonging to or given or endowed for the support of temples. The state legislation vests the supervision of public temples in a statutory authority, that is, Commissioner of Hindu Religious Endowments. For the purpose of meeting the expenses of the Commissioner and his staff, every Hindu temple in the state is required under provisions of the state legislation to pay an annual contribution at certain percentage of their annual income. In the given situation, which of the following statements is correct regarding the annual contribution provided under the state legislation? So what will be the answer? It is not violative in this scenario. It is option A. It is not violative of the Constitution because its object is the proper administration of religious trusts and institutions. Okay, so this is the true answer, right answer. Clear? So this is the third passage. The Constitution of India guarantees to all its citizens certain fundamental freedoms which are recognized as fundamental rights. So the whole passage is talking about fundamental rights, and also it is talking about reasonable restrictions. Okay, so whenever there are fundamental rights, along with that we have something called as reasonable restrictions. Okay, so here they're saying that fundamental freedoms guaranteed by the constitution are not absolute, as no right can be. Each of these fundamental rights is liable to be controlled, curtailed and regulated to some extent by laws made by the parliament or state legislatures. Accordingly, the Constitution of India lays down the grounds and the purposes for which legislature can impose reasonable restrictions on the rights guaranteed to citizens. The state cannot travel beyond the contours of these reasonable restrictions in curbing the fundamental rights guaranteed to citizens. Okay, so if you have any fundamental rights, okay, whatever it is, right to movement or right to life and personal liberty, whatever it is, whenever constitution has provided you with the fundamental rights, along with those you have certain reasonable restrictions as well. That is what the passage is trying to explain. The court is not concerned with the necessity of the restriction or the wisdom of the policy underlying it, but only whether the restriction is in excess of the requirement and whether the legislature has overstepped the constitutional limitations. Two of the fundamental rights guaranteed to every citizen of India are the right to move freely throughout the territory of India and right to reside and settle in any part of India. So these are the two fundamental rights that are guaranteed to every citizen of India. Okay, so what are they? You can move freely, the citizen can move freely throughout the territory of India, and the other fundamental right is the citizen has right to reside or settle in any part of India. However, the state may impose reasonable restrictions on these rights by law in the interest of the general public or for the protection of interests of any scheduled tribes. Okay, so this is the passage. Now we'll see the questions. Yes. A law was enacted by the Parliament of India which consisted of a provision making it mandatory for every person riding a two-wheeler in India to wear a helmet, failing which such a person was made liable to a fine. Mr. X, a citizen of India, was fined for violation of the said provision. Mr. X challenged the constitutional validity of the said provision. In the given situation, which of the following statements is correct? Here, the provision is violative of the Constitution of India because it is a restriction on the freedom to move freely throughout the territory of India. The provision is not violative of the Constitution of India because it is a reasonable restriction on the freedom to move freely throughout the territory of India. Mr. X's fundamental right to move freely throughout the territory of India is violated, both A and C. So it would be option B. The provision is not violative because whenever the Constitution has provided the fundamental right, that is right to move freely throughout the territory of India, it has certain reasonable restrictions imposed on it. Okay, so because it is a reasonable restriction on the freedom of this particular fundamental right. Clear? So that is the reason it is option B. Next, A group of Indian students of XYZ University located in New Delhi, India posted on social networking sites that they would hold a demonstration outside the university campus protesting against a recently passed law which made it compulsory for university students to wear uniforms while attending classes. The students further threatened to use whatever means necessary to stop the oppression of the students. Therefore, the state authorities placed barricades around the university campus in order to restrict movement of the students carrying out the demonstrating and ensuring that the demonstration does not turn violent. In the given situation, which of the following statements is correct regarding the act of placing the barricades by state authorities? So what is it? Here, the act is not violative of the Constitution of India because it is a reasonable restriction in the interests of general public and not of morality. Clear? Definitely it is not violative of the Constitution, and there has to be a reasonable restriction because here the general interest of the public has been taken into consideration. Clear? Hence it is option B. Next, the appropriate authority in a state passed an externment order against Mr. A citizen of India. The externment order prohibited Mr. A from residing within the state from the date specified in such order. What is an externment order? Somebody, externment order is nothing but the person will be prohibited to live in that particular area. It's clearly mentioned, right? He's prohibited from residing within the state, okay, for certain period of time. The externment order was passed by virtue of powers conferred on appropriate authority by law, and the constitutional validity of this law has been upheld by the Supreme Court of India. The externment order was passed on the ground that Mr. A was found to be frequently engaged in illegal business of narcotic drugs and was also involved in several cases of riots and criminal intimidation. In the given situation, which of the following statements is correct regarding the externment order? It is a very direct question. It is option A. It is a reasonable restriction on Mr. A's fundamental right of free movement throughout the territory of India because he is a criminal, because he is involved in many illegal activities. Clear? Next. Mr. Z, a citizen of India, was issued a passport on June 1st, 2020 by the passport office. Mr. Z was due to travel to Spain on July 15, 2021. On July 11, 2021, Mr. Z received a letter from the regional passport officer intimating him that it was decided by the government of India to seize his passport in public interest. Mr. Z was required to surrender his passport within 7 days of the receipt of that letter. In the given situation, which of the following statements is correct? This is also a direct question. It is option D. Mr. Z cannot challenge the letter on the ground that it is violative of his fundamental rights of free movement throughout the territory of India and or to residence and settlement in any part of India. Clear? Because here the passport is seized in public interest. Clear? So that can be considered as a reasonable restriction. So hence it would be option D. Yes. Which of the following statements is incorrect? Fundamental right to movement and residence in any part of India are sacrosanct and are guaranteed to all citizens. Sacrosanct is nothing but very important. Okay, the term sacrosanct is nothing but something which is very important. Clear? So this is a true statement. It is it guarantees fundamental right to movement and residence in any part of India is important and it is guaranteed to all citizens. And the option B is also same, but then it is saying that subject to reasonable restrictions on such rights. Okay, in addition to this they have added reasonable restrictions, so this is also true. Reasonable restrictions may be imposed on fundamental rights to movement of movement and residence in any part of India by law. This is also true. The constitutional validity of a law imposing reasonable restrictions on fundamental rights can be challenged by a citizen before the legislature. This is an incorrect statement and this is the right answer. Why it is an incorrect statement? It cannot be challenged before the legislature. It can only be challenged either in High Court or Supreme Court because it is violation. It is something which is related to fundamental rights, and fundamental rights, if they are being violated, you can only file a writ petition either in High Court or Supreme Court. So hence it is option D. Clear? So with this we have completed this passage. Now we'll move on to the next. Yes, the next passage is on bigamy. So here they have defined what bigamy is and what is the punishment for it. Okay. So where a spouse contracts a second marriage while the first marriage is still subsisting, the spouse would be guilty of the offense of bigamy, and under the penal law in India, if it is proved that the first as well as the second marriages were legally valid, okay, if both first and second marriages are legally valid, that is, all the necessary ceremonies required by law or by custom have been performed at the time of contracting the marriages. According to the penal law in India, if a person who has a living husband or wife marries again, then such a person is liable to be punished with imprisonment up to 7 years along with the fine for committing the offense of bigamy. Although the penal law of India is applicable to citizens irrespective of their religious affiliations, an exception to the offense of bigamy may be created by law relating to marriage applicable to the followers of a particular religion. Okay, so generally here it is saying that bigamy is applicable to all the citizens irrespective of their religious affiliations. Okay, but there is an exception for this offense of bigamy. So if there is any particular religion that where this type of marriage is applicable, so it can be an exception. Under the Hindu law relating to marriage, bigamy is not permitted. Okay, so under Hindu law, bigamy is not permitted. If a Hindu wife files a criminal complaint against her husband on the ground that during the subsistence of her marriage, her husband had married a second wife by converting into another religion which legally permits having more than one wife, then husband is liable to be punished for bigamy. Further, the Hindu law relating to marriage also provides that the punishment for offense of bigamy as provided in penal law would be applicable to marriage between two Hindus. So this is the passage. Now we'll answer the questions. Yes. Mr. A Hindu male, has been married to Miss B, a Hindu female. So here both of them belong to same religion. Their marriage was solemnized as per Hindu rites and ceremonies. After his marriage to Miss B, Mr. A underwent religious conversion into religion X, which legally permits males to have two wives. Thereafter, Mr. A got married to C, a female belonging to religion X, in compliance with all the legal requirements of contracting a valid marriage under religion X. In the given situation, which of the following statements is true? So as Mr. A married Mr. C, the marriage of Mr. A and Miss B has become invalid. As Mr. A is not a Hindu, the marriage of Mr. A and Miss B has become invalid. So these two statements are incorrect. Here we are not talking about the validity of the marriage between A and B. And Mr. A's marriage with Miss C has not affected the validity of his marriage with Miss B. So this would be the right answer. So D cannot be the option because these two are incorrect statements. So this will be the true statement. A's marriage with C has not affected the validity of his marriage with Miss B. Next, here it's a similar question, but then let's see. Mr. A, a Hindu male, has been married to Miss B, a Hindu female. Their marriage was solemnized as per Hindu rites and ceremonies. After his marriage to Miss B, Mr. A underwent religious conversion into religion X, which legally permits males to have two wives. Thereafter, Mr. A got married to Miss C, a female belonging to religion X, in compliance with all the requirements of a contracting a valid marriage under religion X. Miss B filed a criminal complaint against Mr. A for committing the offence of bigamy. In the given situation, which of the following statements is true? Mr. A is liable to be punished according to the Hindu law relating to marriage. Mr. A is liable to be punished according to penal law. Mr. A has not committed the offence of bigamy. Okay, so here it is option D. Both A and B are true because he had committed the offence of bigamy both under Hindu law as well as penal law. Clear? Next. Mr. A, a Hindu male, has been married to Miss B, a Hindu female. Their marriage was not solemnized as per Hindu rites and ceremonies or any other custom, but was performed by seeking blessings of their family members. After his marriage to Miss B, Mr. A underwent religious conversion into a religion X, which legally permits males to have two wives. Thereafter, Mr. A got married to Miss C, a female belonging to religion X, in compliance with all the legal requirements of contracting a valid marriage under religion X. Miss B filed a criminal complaint against Mr. A for committing the offence of bigamy. In the given situation, which of the following statements is true? Mr. A has committed the offence of bigamy because he married again during the subsistence of his first marriage. So, Mr. A has not committed the offence of bigamy because his first marriage is not valid. Mr. A has committed the offence of bigamy because he underwent religious conversion in order to contract a bigamous marriage. Mr. A has not committed the offence of bigamy because his second marriage is not valid. So, which of this would be the answer? It is option B. Mr. A has not committed the offence of bigamy because his first marriage is not valid, because it was not solemnized as per the Hindu rites and ceremonies. Okay, they have just performed their wedding by seeking blessings from their family members. Okay, only if it is solemnized, then he has committed the offence of bigamy. Since their marriage was not solemnized, he has not committed the offence of bigamy. Clear? So it is option B. Next. Mr. A, a male belonging to religion P, has married to Miss B, a female belonging to religion P. So A and B married, they got married, and both of them, they belonging to same religion. Their marriage was solemnized in compliance with all the legal requirements of contracting a valid marriage under religion P. Monogamy is espoused as a cherished value by the followers of religion P and provided as a precondition for a valid marriage for the followers of the religion. After his marriage to Miss B, Mr. A underwent religious conversion into a religion Q, which legally permits males to have two wives. Thereafter, Mr. A got married to Miss C, a female belonging to religion Q, in compliance with all the legal requirements of contracting a valid marriage under religion Q. Miss B filed a criminal complaint against Mr. A for committing the offence of bigamy. In the given situation, which of the following statements is true? Mr. A has committed bigamy according to the Hindu law as well as the penal law in India. It is both. Mr. A has committed the offence according to the penal law of India. Mr. A has committed bigamy according to the law relating to the marriage of religion P. Okay, it is both B and C. It can't be A because they belong to religion P. Okay, so there is no scope for Hindu religion. So option A is incorrect. So here both B and C are true. So hence it would be option D. Clear? Next. Which of the following statements is incorrect? So marrying again during lifetime of a husband or wife is a precondition for performing a valid Hindu marriage. This is a incorrect statement. Religious conversion is not a defense for the offense of bigamy under penal law of India. This is true. Bigamy is offense under penal law of India. True. Offense of bigamy can be committed according to the provisions of Hindu law relating to marriage. So this is the true statement. Clear? Okay. So with this we have completed this passage. Yes, the next passage, a special marriage, that is a marriage between persons from two different religious affiliations, can be legally contracted in India under the provisions of the law relating to special marriages. The law relating to special marriages provides for registration of such marriages and for divorce in such cases. So here they have given the procedure how it has to be done. Okay, whenever two people from two different religions got married, what is the procedure for them to file for divorce? Okay, so the divorce can be terminated by mutual consent of parties to the marriage. So in order to obtain divorce by mutual consent, both the parties to the special marriage are required to jointly present a petition for the divorce to the district court on the ground that they have been living separately for 1 year or more, that they have not been able to live together, and that they have mutually agreed that the marriage should be dissolved at least 6 months after the presentation of such petition, but not later than 18 months. So it should be between 6 to 18 months after the presentation of such petition. The district court, after hearing the parties and after making the necessary inquiry and being satisfied that the marriage is a special marriage and that the claims made in the petition are true, shall declare the marriage to be dissolved. Further, the personal presence of the parties before the district court at the time of presenting the joint petition for divorce is not mandatory, as the parties can satisfy the court even by affidavit that the requirements for granting divorce on mutual consent are fulfilled. So this is the passage. Next, Miss A, a Hindu female, and Mr. B, a Christian male, got married as per the law relating to special marriages on January 2018. On January 26, 2021, Miss A and Mr. B jointly presented a petition for divorce by mutual consent before the district court on the ground that they have been inflicting mental cruelty on each other for a period of 3 years, and they have mutually agreed that the marriage should be dissolved. In the given situation, which of the following statement is correct? The district court shall pass a decree of divorce within 6 months. No, it has to be after 6 months. Next, the district court shall pass a decree after 18 months. No, it has to be before 18 months. The district court shall not immediately pass a decree of divorce by mutual consent. The district court shall immediately pass a decree of divorce. No, it should not be passed immediately. So option C is the right answer. It shall not pass immediately. Okay, the decree cannot be passed immediately. Next, so here also it is same. Let us just see what it is here. They have got married. So here the date has been changed. On February 15, 2021, Miss A presented a petition for divorce by mutual consent before the district court on the ground that Miss A and Mr. B have been living separately for a period of 1 year because Mr. B has been in adulterous relationship with Miss X, a Christian female. In the given situation, which of the following statements is correct? So the district court shall pass a decree of divorce by mutual consent 6 months after the date of presentation of the petition. Okay, here it is a very direct question. If you observe, if you have read the passage clearly, it clearly says that yes, Yes, in order to obtain a divorce by mutual consent, both the parties to the special marriage are required to jointly present a petition. But in this scenario, Miss A presented a petition for divorce. Okay, Mr. B is not there. Okay, so it is not a joint petition. So thus option C would be the right answer. The district court shall not pass a decree of divorce by mutual consent as the requirements for the grant of divorce are not fulfilled. Next, Miss A, a Hindu female, and Mr. B, a Christian male, got married. Yes, got married as per the law relating to special marriages in January 2018. On April 10, 2021, Miss A and Mr. B jointly presented a petition for divorce by mutual consent before the district court on the ground that they have been living separately for a period of 3 years and that they have mutually agreed that the marriage should be dissolved. In the given situation, which of the following statement is true? This is a direct question. It is option A. The district court shall pass a decree of divorce by mutual consent after all other legal requirements are fulfilled. Clear? So in option B says that shall pass a decree by mutual consent immediately because they have been living separately for more than 1 year. No, this is not true. And then the district court shall not pass a decree by because the marriage between is not valid. The district court shall not pass a decree by mutual consent because neither parties faulted the marriage. So these options are very irrelevant. So option A would be the right answer. Next, Miss A, a Hindu female, and Mr. B, a Christian male, got married as per the provisions of the law relating to special marriages in January 2018. On June 16, 2021, Miss A and Mr. B jointly presented the petition for divorce by mutual consent before the district court on the ground that they have been living separately for a period of 3 years and that they have mutually agreed that the marriage should be dissolved. During the presentation of the petition, while Miss A was present physically in the district court, Mr. B joined via video conferencing. In the given situation, which of the following statements is correct? The district court may pass a decree of divorce by mutual consent 6 months after the date of presentation of the petition for divorce. The district court shall pass a decree of divorce by mutual consent after all legal requirements are fulfilled. The district court shall not pass a decree of divorce by mutual consent. This is totally incorrect statement. Option A and option B are true. So hence it is option D. D is the true right answer. Next, Miss A, a Hindu female, and Mr. B, a Christian male, got married as per the law relating to special marriages in January 2018. On March 15, 2021, Miss A and Mr. B jointly presented a petition for divorce before the district court on the ground that they have been living separately for a period of 3 years and they have mutually agreed that the marriage should be dissolved. 6 months later, the district court, after hearing the parties and making inquiry, found that the marriage had been solemnized under the law relating to special marriages and that the consent of Miss A for the presentation of petition was obtained by fraud. Okay, in the given situation, which of the following statements is incorrect? Very direct question. The district court shall not pass a decree of divorce because there was no mutual consent, because the petition for divorce was obtained by fraud. Clear? So yes, we have completed the analysis of this passage. Yes, so here this passage is talking about two concepts called monism and dualism. Okay, so and the relationship between international law and domestic law as far as these two topics are concerned. So the monistic theory maintains that the subjects of two systems of law, that is international law and municipal law, are essentially one. Okay, so monism is saying, under monistic theory, it is saying that both international and municipal law are essentially one. The monistic theory asserts that international law and municipal law are fundamentally the same in nature and arise from the same science of law, and are manifestations of a single conception of law. The followers of this theory view international law and municipal law as part of the universal body of legal rules binding all human beings collectively or singly. In a monist system, international law does not need to be incorporated into domestic law because international law immediately becomes incorporated into domestic legal system upon ratification of an international treaty. Okay, this is an important part in the passage. Okay, whenever there has to be a new, yes, international law does not need to incorporate into domestic law because it immediately becomes incorporated into the domestic legal system. According to this theory, domestic law is subordinate to international law. Okay, domestic law is subordinate to international law under monistic theory. The statute of International Criminal Code therefore can directly applied and adjudicated in national courts according to monistic theory. According to dualism, international law and municipal law represent two entirely distinct legal systems. Okay, that means international law has an extrinsically different character from that of municipal law. International law is not directly applicable in the domestic system under dualism. First, international law must be translated into state legislation before the domestic courts can apply it. For example, under dualism, ratification of the statute of the International Criminal Court is not enough. It must be implemented through state legislation into domestic system. Most states and courts presumptively view national and international legal system as discrete entities and routinely discuss in dualist fashion incorporation of rules from one system to the other. So here under monism, both international law and domestic law are the same. Okay, I mean they are of the same nature, whereas under dualism they are two different entities. Okay, if there is any kind of statute that has been implemented, then it has to be implemented separately in the domestic system as well. So now let's see the answers. In the light of the given passage, which of the following statements is true? Monism and dualism are similar approaches to adopt international law into domestic law. No, because monism is for monism this is true. International law, it will adopt international law into domestic law, but for dualism they are two different entities. Dualism postulates the homogeneousness of domestic law and international law. Monism and dualism are different approaches to understand how domestic law impacts international law. Monism postulates the homogeneousness of international law and domestic law. So option D is the correct statement. Next, X is a developing country. X ratified United Nations Framework Convention on Climate Change in 1995 and incorporated the provisions of the said convention in its domestic legislation addressing climate change in 1996. However, X has been widely criticized in the international community for its failure in meeting the obligations under the said convention. Why is it developed country? Y ratified the United Nations Framework Convention on Climate Change in 1995 and has not incorporated the provisions of the said convention in its domestic legislation till date. Y has been appreciated by the international community for its success in meeting the obligations under the said convention. In the given situation, which of the following statements is correct? So here it clearly says that X is a dualist state and Y is a monist state. Clear? Because here X has ratified this convention and incorporated the same convention in its domestic legislation as well. So it is a dualist state, and Y, it is a monist state. Next, D, a dualist state has signed and ratified the agreement on TRIPS, an international agreement administered by the WTO. If D is compelled to fulfill its international obligations under the TRIPS agreement, which of the following statements is correct? D may adopt the provisions of the TRIPS agreement without enacting a new domestic legislation or amending an existing legislation. D may not incorporate definitely it has to incorporate. So this is a wrong option. It may not is also wrong option, so it is option C. It must incorporate the provisions of TRIPS agreement into an existing domestic legislation or in a new domestic legislation. Which of the following statements is incorrect? According to monism, the nature of domestic law and international law is the same, and domestic law is subordinate to international law. Next, according to monism, ratified international conventions automatically become part of domestic law, and domestic law is subordinate to international law. According to dualism, ratified international conventions automatically become part of domestic law, and domestic law is subordinate to international law. So this is an incorrect statement, so it is true. According to dualism, the nature of domestic law and international law is different, and domestic law is not subordinate to international. This is not, so yes, all this other than A, B and D, this is the incorrect statement. So hence it is option C. Next, the country X has ratified an international convention which requires each state party to enact laws defining and punishing bribery, that is the act of offering bribes to government officials. The convention has neither defined bribery nor prescribed a punishment for the same, so that each state party may define the offence of bribery differently in respective domestic legislations. By 2022, X has not enacted any law defining and punishing the offence of bribery. Okay, so what is it here? X has not enacted any law which talks about bribery. But in the year 2021 November, Mr. A was being prosecuted by a domestic criminal court in X for allegedly offering a bribe to a government official. In the given situation, which of the following statements is correct? This is a very direct question. It is option A. Mr. A cannot be punished for committing an offence under the convention irrespective of whether X is a monist or dualist state. Okay. Here the question is not about monist state or dualist state. Okay. First thing is here they have not defined the offence of bribery, the punishment or whatever it is. Okay. Because this happened in 2021, but by 2022 also they have not enacted it. So it is option D. Clear? So we have completed this passage. Yes, so this particular passage is about sustainable development. So United Nations Commission on Environment and Development defines sustainable development as follows. So this is the definition of sustainable development. Preserving the resources for the future generations. Sustainable development clearly postulates an anthropocentric bias least concerned with the rights of the other species which live on this earth. Anthropocentrism is always human interest focused thinking that considers non-humans as having only instrumental value to humans. In other words, human state precedence and human responsibilities towards non-human are based on benefits to humans. Ecocentrism is nature-centered, where humans are part of nature and non-humans have intrinsic value. In other words, human interest does not take automatic precedence and humans have obligations towards non-humans independently of human interest. Ecocentrism is therefore life-centered, not nature-centered, where nature includes both humans and non-humans. So here ecocentric means it includes both humans and non-humans. The Constitution of India protects not only human rights but also casts an obligation on human beings to protect and preserve a species from becoming extinct. Conservation and protection of environment is an inseparable part of fundamental right to life. So they have discussed about two concepts. One is anthropocentrism and ecocentrism based on the sustainable development. According to the doctrine of public interest, recognized under the Constitution of India, certain common properties such as rivers, seahorses, forests and the air are held by the government in trusteeship for the free and unimpeded use of the general public. The resources like air, sea, waters and the forest have a great importance to the people as a whole, that it would be totally unjustified to make them a subject of private ownership. The state as a custodian of natural resources has a duty to maintain them not merely for the benefit of the public but for the best interest of flora and fauna, wildlife and so on. Okay, it's not for the benefit of the public but for the best interest of the flora and fauna and wildlife. Clear? Yes. Miss G, a student of environmental science, has cultivated a butterfly garden which provides a favorable habitat for butterflies. Miss G has cultivated the butterfly garden so that she could observe and study the different stages of development of butterflies such as egg, larvae, pupae and adult. In the given situation, which of the following statements is correct? Okay, definitely this is an anthropocentric project. Okay, it is anthropocentric. Okay, so here both option A and B are saying that it is anthropocentric. So the reasons are, first thing is that it is for the conservation of environment and it is for her academic interest. So it is not for the conservation of environment because here it's clearly said that she could observe and study the different stages. Okay, so it's completely for her academic interest. So it's option A. Next, which of the following statements is correct? Anthropocentrism and ecocentrism are different approaches to achieving sustainable development. Anthropocentrism focuses on the promotion of non-human interests. Ecocentrism is concerned with the promotion of both human and non-human interests. This is the true statement. Anthropocentrism and ecocentrism are different approaches to protection of environment and sustainable development. So option C is the right answer. It's clearly mentioned in the passage. It includes both human and non-human. Which of the following is the basis for the difference between anthropocentrism and ecocentrism? The inherent value placed on humans and non-humans. Option A. That is the main difference between anthropocentrism and ecocentrism. It's not living things or non-living things. It's not the relationship between human society or environment or non-humans and environment. It's about humans and non-humans. Which of the following statements is correct regarding fundamental right to life under the Constitution of India? It creates a corresponding duty on human beings to protect and preserve non-humans. It creates a corresponding duty on non-humans to know. This is an incorrect statement. It is inclusive of the right of human beings to utilize non-human resources to the best of their advantage. It is inclusive of the right of the non-humans to, this is also in, these two also are incorrect. So option A is the true statement. Okay, it creates a corresponding duty on human beings to protect and preserve non-humans. Next, which of the following statements is incorrect according to the doctrine of public trust? State is obligated to maintain forests for their economic value. No, it is clearly mentioned in the passage that they are not maintaining it for the benefit of the public. Okay, they're maintaining it for the best interest of flora, fauna, wildlife and so on. Clear? There is no they're not maintaining it for any kind of economic value. So this is an incorrect statement. Yes, so this is the last passage. Okay, so this passage is talking about mistake. So we have two concepts here, mistake of fact and mistake of law. So let's see what this passage is talking about. When parties to a contract are under mistake regarding an important fact related to such contract, it may affect the contract in two ways. The first one is it defeats the consent altogether that the parties are supposed to have given. That is to say that the consent is unreal. Okay. So whenever there is the mistake of fact, that too the important fact that is related to the contract, it is going to affect, it is going to defeat the consent altogether. That means there is no consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. Secondly, the mistake may mislead the parties as to purpose which they had contemplated. Okay, totally they might deviate from the contractual obligations. When the mistake does not defeat the consent but only misleads the parties, that is where both the parties to an agreement are under a mistake as to matter of fact essential to the agreement is void. However, if the mistake is concerning an erroneous opinion regarding the value of the subject matter of agreement, it is not a mistake as to matter of fact. Thus, agreement is void when both the parties of an agreement to an agreement are mistaken. Their mistake is as to a matter of fact, and the fact about which they are mistaken is an essential to the agreement. So these are the three conditions here where the agreement can be void. Further, it is pertinent to note that a mistake in order to invalidate a contract should be a mistake of fact and not a mistake of law. Furthermore, where only one party to the contract is under mistake of fact and the other party is not, the contract is not voidable merely for such reason. Okay, whenever only one of the party is under the mistake of fact, then the contract is not voidable. That is what it means. So now the first question of this passage. Mr. X entered into an agreement to sell his bicycle which had been kept unused in his attic for a year to Mr. B at an agreed price. However, neither party was aware that at the time of the entering into the contract, the bicycle had been already destroyed by fire in the attic. In the given situation, which of the following statements is true? It is void. Option A and option B are saying void. But here it is talking about mistake of law, it is talking about mistake of fact. So it is mistake of fact. Both have thought that the bicycle is still there, but then unfortunately it was destroyed by a fire. So it is option A. The agreement is void as both parties were under a mistake as to matter of fact essential to the agreement. So here the essential element is bicycle. Okay, that bicycle is only destroyed. Clear? It is option A. Next, Miss X and Miss Y entered into a contract for sale of an article while reeling under the erroneous belief that the sale of the article, which was the subject matter of the agreement, was permitted by law in force. In the given situation, which of the following statements is true? The contract is valid? No. The contract is voidable at the option of Miss X. The contract is voidable at the option of Miss Y. The contract is not voidable. It is option D here. The contract is not voidable because there is an erroneous belief that the sale of the article, which was the subject matter of the agreement, was permitted by law in force in India. Okay, so for this reason it is not voidable. Mr. J entered into an agreement with Mr. K for the sale of Mr. J's club. At the time of entering into the agreement, while Mr. J believed that he was agreeing to sell his golf club, Mr. K believed that he was agreeing to buy a clubhouse owned by Mr. J. The agreement is void because mistake of fact defeated the consent of the parties. Mistake of fact misled the parties as to purpose of the contract. Mistake of fact was regarding the identity of the parties. It is not about the identity of the parties. It is about the clubhouse, and here he thought that he was selling, it's about the golf club and clubhouse. Okay, so here the consent was defeated and also it misled the parties. So both A and B are true. So it is option D. Next, Mr. D appointed Mr. K to manage the cultivation of his land as he was unable to manage it himself due to his advanced age. Mr. K agreed to manage the cultivation of Mr. D's land if he granted Mr. K a lease of the said land. Mr. D agreed to the same and signed the deed, which was unknown to both the parties, a gift deed of the land and not a lease deed. In the given situation, which of the following statements is true? It is option A. Mr. D and Mr. K were reeling under a mistake as to a matter of fact essential to the agreement. Okay, clear? Both of them were under the mistake, and it is a mistake of fact. It is not a lease deed, but it is a gift deed. So both Mr. D agreed the same and signed the deed, which was unknown to both the parties. So both D and K are unaware that it is a gift deed. It should be a lease deed. So it is option A. Next, Miss X and Miss Y entered into a contract of sale of an article which shipped by Miss X in ship named the cruiser and delivered to Miss Y on an agreed date. Mr. X shipped the said article by different ship named the Mariner without informing Miss Y, and the said article was delivered to Miss Y on the agreed date. In the given situation, which of the following statements is true? Definitely it is valid. The agreement is valid. So it can be either C or D. So which one is the right answer? The agreement is valid as both parties were under mistake as to matter of fact not essential to the agreement. The agreement is valid as both parties were under mistake as to matter of fact essential to the agreement. Here the question is whether the matter of fact is essential or not. Clear? Ultimately the goods had been delivered. Clear? Yes or no? Whatever the article it is, the article was delivered finally. Here that is the essential to the agreement. The article is essential. Doesn't matter if it is what the name of the ship is irrelevant. It is not that essential. So it is option C. The agreement is invalid as both parties were under a mistake as to a matter of fact not essential to the agreement. So with this we have completed all the passages. We have analyzed the passages. So I hope it's clear. I hope all of you have understood. Thank you so much.